so many people that are wanting to be involved in our government. Personally speaking, we have a serious problem in this country right now. And as conservatives, we have a big fight on our hands to take back our government. You know as well as I do what's going on in our government. We're seeing highest inflation we've seen in 40 years. Gas prices out the roof. Families having trouble feeding themselves, deciding whether to put gas in their tank or whether to put food on their table. Very trying times, tumultuous times. We have to be more careful now about electing our officials than probably any time in history. Scary times are ahead, but if we all act with intelligence and being informed, we'll put better candidates out here, and candidates that will reflect our values of what we need as Americans. We have a couple of outstanding citizens right here. I know both of them. I know their family, I know their background. A lot of you may not know them. Our voters of St. Francis County, for the most part, may not know who these candidates are. But with forums like this, we're going to inform voters about who these folks are, what they stand for, and hopefully you folks, as well as others, can make a better educated decision about who we put in office. So with that, we're going to allow opening statements now from each of our candidates. And we'll come back with a series of questions that we'll ask each candidate. They'll have 2 minutes each to give their answers. So we're going to start tonight with Pat King. Pat?
Thank you, Fred. Good evening. I hope you can hear me. That's not one of the complaints about me, that I can't be heard. I think you'll be able to hear me this evening. My name is Pat King, as Fred said. I am currently serving as Associate Circuit Judge, Division 4 for St. Francis County. I was born and raised on the family farm in Phelps County. I come from a long line of farmers. In fact, I believe I'm the first child in my family to graduate from a four-year university. I went to Mizzou Law School, and then after that, I started my legal career. I spent time in the Attorney General's office, and then for much of the intervening 28 years, I spent as a career prosecutor, including just about 20 years here in St. Francis County. In the midst of that as well, however, I also engaged in a wide-ranging civil practice, and I practiced law in a number of different disciplines, including divorces, probate cases, and other cases where I thought I could be helpful. So I had a wide range of experience when I arrived here. After I arrived here, I was the Chief Assistant Prosecutor for nearly 20 years. During that time, I got to know you, for lack of a better term. I got to know you. Something I've learned as I've been out on the campaign trail for the last several months is that so many people across St. Francis County know me and know the kind of work that I've tried to do for the last 24 years. 20 as a prosecutor, in the last 4 years as judge. And they are appreciative of it. I have earned their trust. I have earned their trust by virtue of doing what I said I would do, which is work hard for the people of the county. Now, 4 years ago, quite a number of people came to me and said, we would like for you to run for judge. And it was not something I had considered, but I did consider it because I had so many folks that I respected across all walks of life that had something to do with the court system that asked me to run. And so I ran, and with the help of so many of you that are in this room tonight, we were successful, and I was elected judge. I've been Associate Circuit Judge since January 1st, 2019. During that time, I've had a number of opportunities to serve in various ways. The circuit clerk was approached by 3 municipalities in St. Francis County about taking over the municipal court. One of those was Leadington, and one of those was Leadwood, and then Iron Mountain Lake. So for the last period of time, I've served as a municipal court judge in addition to my other duties for those 3 municipalities. I was also approached by statewide judges about helping edit a book that is used by judges throughout the state called the Missouri Criminal Bench Book, and I was glad and proud to do that, and so I was successful in doing that. I've had a wide-ranging career as far as community service is concerned, and my understanding is we'll have a question where I'll be able to discuss that more with you. I have a record of community service which was in part the cause of the being recognized by the Farmington Chamber of Commerce as their Citizen of the Year a few years back. And we'll talk more about that in just a few minutes. The proudest part of my life is that I'm married to my wife, Michelle. We've been married for 35 years, or right at 35 years. We have 2 beautiful children who are adults now, Andrew and Melanie, and I'm quite proud of them. I can only hope that they're proud of me. Thank you so much.
Julie?
My name is Julie McCarver. I am also running for St. Francis County Associate Circuit Judge. I am a Republican. I first of all would like to thank the Conservative Club for arranging this tonight. I know that a lot of hard work into putting this together, so a round of applause for the Conservative Club that worked very hard tonight. I want to thank Mr. Dawkins for agreeing to moderate, so a round of applause for him as well. I know many of you in this room know me, but some of you do not, and some people watching may not know me. I think back to when I was a young child. At that time, I don't think that I would have ever thought that I would be here today running for judge, which is a great, great honor. I come from a very humble background. My family was poor. I was the first person in my family to receive a bachelor's degree, and certainly was the first person to receive a law degree. I'm the oldest of 5 children. My mom currently works at Walmart. My dad was a talented but starving artist before he was disabled and before he passed away. I had my very first job at the age of 12 as an assistant secretary, small jobs in between. And then my second job at the age of 16 was a union job. I worked my way through college. I received 2 bachelor's degrees. I went to the University of Missouri in Kansas City. I went straight to law school where I received good grades, and I was also on the Kansas Law Review. And for the lawyers in the room, you know that that is a great honor in law school. Following graduating from law school, was immediately hired at a large law firm in Kansas City. I took the Kansas bar and then the Missouri bar in less than 1 year and passed both the first try. I worked at a large law firm in Kansas City, and then I moved closer to home because my father was in poor health. So I took a job at a small law firm in Hillsborough, which I worked at for many years. And then following that, I moved my practice down to Farmington in 2010. And since that time, I have had a thriving small business. I have been honored to be a municipal prosecutor in the cities of Park Hills, Farmington, and now in Bismarck. My husband, Sean Carver, and I have been married for almost 16 years now. We live in Farmington with our 14-year-old daughter and our 3 German Shepherd dogs and 1 bunny rabbit. We are active members of our church community in Farmington. My husband, Sean McCarver, is originally from Flat River, where his family owned a small business on Main Street. My mom is originally from Deloge, and my grandma is originally from Elvins. I want to address 3 attributes that I think I have, which would allow me to be an excellent associate circuit judge. First are my conservative values. I was the founding member of the St. Francis County Conservative Club, and I was the secretary until recently when I stepped down so I could run for judge. I was the charter member for the Eastern Missouri Conservative Club. In April 2021, I had the honor by Liberty Alliance being announced as Conservative Champion of the Week. I have served as a Republican presidential delegate. I have helped a number of other Republicans run for office. I am a proud member of the NRA and a defender of our Second Amendment rights. My husband is a federally licensed firearms dealer. I am pro-God, pro-gun, and pro-life. I believe that I have the experience for this position, which is probate judge. This position also does 50% of domestic cases in St. Francis County, mental health commitment cases, juvenile cases, and as Judge King stated, 3 municipal courts in St. Francis County. I have done this type of work my entire career. I have been a municipal prosecutor, as you have heard. I have done probate law, domestic and civil, and I have had the honor of taking 2 domestic cases to the Missouri Supreme Court and 4 cases to the Court of Appeals last year alone, 1 probate and 3 domestic.
All right, we're going to go to the questions now. And I believe the first one will go to Pat King. Is that correct, Harry? All right. Question number 1. This is addressed to Pat King, and Julie McCarver will respond. You are both very upstanding citizens of our community, no doubt about that. What have you done to make St. Francis County better? And if you have been involved in community organizations, which ones? And what compels you to get involved, Mr. King?
Thank you, Fred. I can tell you the organizations I've been a part of. A more interesting question is what compels me to get involved. I think about, to turn a little bit on the phrase that Martin Luther King talked about the Good Samaritan. As the others passed the person lying there, they said, if I stop to help him, what will happen to me? Martin Luther King said, the Good Samaritan walked by and said, if I do not stop to help him, what will happen to him? And I think that's the kind of attitude that gets any of us, all of us, involved in community service. We see a need. We see a need in the community. We see a need somewhere, and we move to address it. One of my longest associations is with the worldwide service organization called Kiwanis. Kiwanis has been active for over 100 years. We have a Kiwanis Club in Farmington. I've been a Kiwanian for over 30 years. Through that, I became more or less a founder of the Key Club at Farmington High School, or got it back started again after several years of being dormant. And because of my involvement with the schools, both as a parent and as a community member, I was honored on 2 separate occasions as a Heartland Hero by the Farmington School District. I was asked to serve on the board of the Baptist Home, which is a group of living homes in Missouri that were founded by Missouri Baptists, and that's been one of my proud associations. Several years ago, Farmington School District got involved in character education. They asked me to be a part of that at the beginning of the character education process. Through that, I became part of the Extended Character Council of Farmington Middle School, and they are still active today. I was active with the Children's Advocacy Center of East Central Missouri, and because of that, time? Wow.
That's all I'm going to say.
I've got more to say, but I'll save it till later. Thank you.
The 4 organizations I've been the most involved in with our community in St. Francis County have been the St. Francis County Mental Health Board, which I have had the honor to work with. A question is, why have we done this volunteer work? I have had an opportunity to have contact with many people in St. Francis County and other counties as well who have had mental health problems. I have done this in criminal cases, in juvenile cases, and domestic cases, and have seen how much the issue of mental health has really impacted our community. And I wanted to get involved with that organization, which was doing a lot of good work in being a liaison between mental health professionals in the community of St. Francis County. Additionally, myself and my husband and our child have been very active in our church, which is St. Joseph Church in Farmington. Additionally, my daughter went to school for a period of time at St. Joseph. We were volunteers both for the church. We have many different things that we do through the church. We try to invite people. It doesn't just have to be people from our church, many different people throughout the community. And we have volunteered extensively for them. We have volunteered for Nutcracker, I think every other year since 2012. We support the arts in our community, and we have felt that it's very important to support that organization. Additionally, I have volunteered for Single Family Violence Council and the Women's Shelter in Bon Terre, and I have done that because I'm very passionate of domestic violence, because myself and my friends have been victims from a former relationship. Additionally, I've done domestic work and have seen many victims of domestic violence and wanted to do something good for the community of people who are victims of domestic violence.
Do you have a rebuttal?
Well, I don't have a rebuttal, but I'd like to say the two things that I wanted to say a minute ago, which are that some of you, and I look out here and I see several of you who have been involved with the Farm to Ministerial Alliance, Food Pantry, and Thrift Store Ministries, and I have been chairman of that board for the last 18 years, and we have done a lot of work, fed a lot of folks in this community. Because of that kind of work, I was honored by the Farmington Chamber with the Daily Journal Farmington Press Citizen of the Year Award, and I view that as recognition by the community of the things that I've been able to accomplish. I've been as well a dedicated lay member and deacon at Farmington First Baptist Church. Very rewarding work. I hope that's 45 seconds. Thank you.
Because of my personal and professional experience with domestic violence, I have started volunteering for Single Family Violence Council and their Women's Shelter. I felt that the fact that I and my friends have been victims of domestic violence, and again, this is a former romantic relationship, just so that's clear. I feel like I have the experience of, from a legal standpoint, but also from a personal standpoint, to help domestic violence victims and to talk them through different situations that they have had.
Okay, we're going to go to question number 2. This one will be poised to Ms. McCarver. She'll respond first, and then Hakeem will respond. For many people, you are just a name on a sign or on the ballot. To you, what's the most important aspect of your personality, including your knowledge or experience, that would make voters confident that you are the correct person for the position? Ms. McCarver.
Thank you. And I've been told by many friends and many clients that I have had over the years that in court I'm very calm, intuitive, and compassionate. And I think that is important in the private practice of law, but also important if I were to be honored with being a judge. I was a law review in law school. I have done many appeals in addition to work in the Missouri Supreme Court. I am an excellent legal writer and researcher, which I think would be important and would assist me in being an associate circuit judge. Because I am calm, I believe that I would be able to be respectful to those who appear in front of the court. And because of my humble upbringing, I believe that I am a down-to-earth person. I have been the victim of crime. Back in 2020, my father was murdered by a neighbor who had had a number of different violent situations that have occurred, but he was not in jail, unfortunately. I believe because of my personal experience that I can be compassionate towards those people who appear in front of the court. And in law school, they teach us to see things from more than one side. I've been a prosecutor. I have defended people in court too. But this is a new perspective that I have because of being the victim of crime. And I think that that can help me have compassion for those people who appear in front of the court.
Mr. King.
The single most important virtue that I believe is critical for a judge to have is honesty. Simply stated, you have to be able to trust them. You have to be able to trust them to do what they say they will do. You have to have absolute implicit faith in their integrity from the get-go. That is what I said to people when I ran for this office 4 years ago. That is what I believe I brought to the bench. And that is the quality that I have displayed that's been the most critical. And that is why I believe that folks have continued to support me demonstrate that they appreciate what I've done, simply because I did what I said I would do, and I've kept the faith of the people of the county. Honesty is the most critical thing you can bring to the bench.
All right, we're going to move on to question number 3. This will be addressed to Mr. King. Mr. King, describe your overall judicial philosophy and what approach do or will you take as a judge?
Well, I think whoever wrote this question wants us to talk about whether, how we feel about whether we're being an activist judge, we want to really reach out there, or we want to be more restrained, we want to exercise our power less often. The fact of the matter is, I'm a trial judge, which means that I have to critically, most importantly, be concerned with whether the folks in the courtroom receive a fair trial. You have to be fair and impartial, and that has several parts to it. The first part, I believe, is that you have to make sure that every person has notice that needs to have notice. You have to give every person an opportunity to be heard that needs to be heard. You have to allow the self-represented person. A lot of folks come to court without lawyers. You have to listen to those folks. You have to give them an opportunity to be heard. You treat them fairly. You don't treat them more leniently and say, well, I'll bend over backwards to help you because you don't have a lawyer. You have to treat everyone fairly. And I think once you do that, and once everyone has the opportunity to be heard, everyone has the opportunity to come to court and tell their story, then they will have far more confidence in the outcome of what happens. And so as an overall judicial philosophy, my philosophy is you must be fair and impartial. You must strive for that. Everyone who walks in the courtroom must believe that the judge is fair and impartial and has no side except the truth. And once you do that, then you will have confidence, the people will have confidence in how you decide cases.
Ms. McCarver, the same question to you.
I agree that this is a trial judge position. If I have the honor of being an Associate Circuit Judge, to follow the law as it is written by the Missouri and U.S. Constitution, pursuant to the law of Missouri, and also the municipal ordinance for those municipal cases that this position does. Trial judges should not be activist judges. I agree. We should not impute our personal opinions into cases, but instead we should follow the law as it is written. I have been door knocking extensively in our community. Prior to deciding to run, I had a number of people come to me and ask me to run, and I believe that's because I am a very calm person. In court, my clients have told me the same thing, and I'm a very compassionate and empathetic person. And I think that those are attributes that are very important for a judge, and those are attributes that I would like to continue as a judge. As attorneys, we forget. We enjoy being in the courtroom very much, but that everybody else who's in the courtroom is probably having a bad day. And because of that, we should keep in mind that we should be compassionate towards those people making a decision and try to be understanding of the very serious and emotional situations that are occurring in their cases, and be respectful towards those people despite them having a very difficult time with whatever type of case they have.
Mr. King, you have 45 seconds.
I don't know that I can add anything I said about how I approach, how I work in my courtroom, how I believe that the only thing you can promise people is to be fair and impartial. As a matter of fact, the ethical rules that apply to judges tell us when we seek election as judge, we can only promise to be fair and impartial in doing our work. And that is what I have striven to do since I became judge.
I just would add that a judge should strive to make sure that people before them have a voice, that they believe that the judge is listening to both sides and applying the law fairly. As a private attorney, I have discovered that sometimes all you can really ask from a judge is that they act respectfully towards the parties in the room but also consider the law and they apply it appropriately. And if a judge makes a mistake as to fact or law, that they are humble enough to correct that mistake.
Next question will be directed to Ms. McCarver. Conservatives want judges who think clearly and without relying on emotion. How would you exude power in a courtroom without seeming cold and also without seeming overly impacted emotionally by extremely emotional cases that come before you, Ms. McCarver?
I, to a certain extent, disagree that a judge should seek to exude power. I believe that a judge should be comfortable showing compassion and fairness and listening to all of the people who come before them. Since I've been practicing for almost 20 years, I've seen many judges throughout the years that I thought were good judges and bad judges. And it's not my opinion from all that experience that people actually want judges who have no emotions. I think as human beings, we all have emotions. I can think back to a very emotional juvenile case I had very many years ago. For a 6-month period of time, Judge Missy in Jefferson County gave me nothing but shaken baby cases, which are cases where a child has been shaken and is disabled or is possibly deceased and has a surviving sister or brother. During that case, Mary case, a forensic pathologist from St. Louis showed us photos of horrific evidence that nobody should ever have to see. And I was horrified and sad for the family. And I looked across the courtroom and saw the mother and her boyfriend, and they had, appearing to me, no emotions that I could see during that case. And I think, of course, I acted professionally, but also I am able to see the different emotions of the different people in court, and I feel like that would be helpful to a judge. We are human beings. We all have emotions. And honestly, as a private attorney, I have always wanted my judges to be practical and empathetic and actually have emotions.
Mr. King, you have 45 seconds.
Well, it's a very difficult line to walk to ensure that you retain the authority of the judge in the courtroom. I think that begins when you treat everyone with courtesy and respect, that you ensure that the court personnel and others involved in the cases know what lines can and can't be crossed. But critically important, I think, when you talk about taking emotion out of the situation is you don't make snap judgments. You don't rule often from the bench. Rather, you let that coffee cool, as they say, and go back sometimes, listen to the record, take your time, think about the facts and the law and the evidence before you come to a ruling. That, to me, insulates you from making emotional decisions. Now, adoptions, guardianships, some of you have been in the courtroom, and those take place. Those are happy occasions. And by nature, you share the joy of the folks involved. I've been known to cloud up, shed a tear or two when those events happen. But as far as emotionally making decisions as a judge, you can't afford it. And you have to be measured, and you have to take the time that you need to make the decision. Don't make snap judgments. You don't make decisions based on emotion. You make decisions based on the facts, the law, and the evidence.
And Ms. McCarver?
I agree that it's a difficult line to walk. I've always been able to remain calm during any difficult situation in a courtroom. I have sat in on many difficult cases, juvenile cases especially, which have had difficult sets of circumstances. But as I stated, I feel like it's important for a judge to be able to look out at the people in the courtroom, including witnesses as they testify, people, the defendant or whomever sitting next to their attorney, and also people in the gallery, and try to judge what's going on with those people. And I think that keen desire to understand the people's emotions is very helpful to a judge, and I think that judges should consider that.
Okay, we're going to go on to our next question. This will be asked of Mr. King first. Mr. King, how do you feel about pre-trial, off-the-record discussions with the attorneys to narrow the issues or perhaps settle the case?
Well, short answer is I don't do it. I don't agree with it. Sometimes lawyers will come to me and say, we have this particular issue, we want to talk about it with you, and that's fine. But talking with the lawyers about settling the case, knocking their heads together, so to speak, I don't believe in it at all, and for several reasons. First of all, when I ran for this position 4 years ago, I was told by a number of people, and I had a number of folks tell me as I campaigned, that they went to court, never got to see the judge, everyone went back in the back room, and then the decision was made without them being able to talk with the judge. And I don't believe in that at all. I think you do your work in the courtroom. Second of all, when folks are just talking to you about what you think they ought to do to settle the case, I haven't heard any evidence. I don't know what the evidence is in the case, and I don't know where the evidence may take me. So who am I to be able to sit there and give you an advisory opinion when I haven't heard all the evidence? But third of all, we're told as judges simply, you're not to give advisory opinions. You're not to say, well, if you give me this hypothetical example, I'd probably do this. And when you're talking about people's lives and their fortunes and their children, and those things are so very important, you've got to get it right. So I absolutely do not believe in being a part of informal settlement conferences, forcing the lawyers to settle the case. If they want to, I've had lawyers very often will say, well, we want to go outside and talk and see if we can settle the case. That's fine with me, but I'm there to try the case, and I make it clear to them, I'm here to try the case, and I'm here to hear whatever your clients are here to tell me, and I'm not there to knock heads together and why don't you guys settle this? So I don't believe in doing it, and I think if you want to have a transparent court where everyone knows and can have confidence in the outcome, you don't do it.
Ms. McCarver, how would you respond to that question?
These pre-trial discussions are permitted by the law, but only if the parties agree to do so. In some cases, they can be very helpful, but a judge must make it clear that these discussions are not binding, and that once the judge hears evidence at trial, the decision may be very, very different. I have practiced in a number of different counties, and every county seems to do this differently. But within domestic cases, sometimes attorneys will ask for these conferences because they may be useful to narrowing down issues. And this position does 50% of the domestic cases in St. Francis County. In my private practice, many clients have come to me, sometimes after having a prior attorney, complaining that they feel like the attorneys went to a back room and had a discussion and they felt left out of the process and didn't really know what was going on back there. So despite my believing that this type of process may be helpful, I think that it might be better to do things in a slightly different way that I've seen done in other counties previously. If all the parties agree to a pretrial discussion and feel like it might be helpful to them in settling the case, I, as a judge, would typically be willing to do a discussion like that, but I would, after the discussion with the attorneys, bring the parties out and have a real discussion with them about whether or not they feel like they're being heard, whether or not they agree with whatever agreement that the attorneys have discussed, and I think that would make them feel better about the process. I do not want any parties in the court to feel like they are coerced, but I feel like it's a practical way to allow parties to come to agreements. Because in my experience, people in domestic cases, when they come to an agreement, they end up being much, much happier in the long run.
Mr. King, you have 45 seconds.
I'm all in favor of settling cases. Most cases do settle. Me as the judge being involved in the settlement is what the question talks about, and I as the judge am not going to be involved in the settlement. I'm not going to tell the parties what I think they ought to do. I'm not going to tell the lawyers what I think they ought to do. I think it's wrong for the reasons that I've said. I think I should make decisions based on evidence. And I think it's wrong to make decisions when you don't have all the evidence. And it's wrong to try to coerce parties into a settlement. And it's wrong to give them the idea that they're there to settle the case. What if they don't want to settle the case? Let's have a trial. And it's something that I just don't believe in. So, and my attitude on that is based on experience and based on what folks have told me.
And Ms. McCarver?
I suppose I'm just more practical about this situation. I have been a private attorney for almost 20 years now. I have done an extensive amount of domestic work. And in my experience, attorneys sometimes actually want to have discussions with a judge. And if both attorneys are agreeing and both parties are agreeing that they want to have a discussion about their case, I don't see why I would refuse to allow them to have that type of discussion. Again, in my experience, parties who are able to reach an agreement by any means are much happier with whatever the situation is once court is done. And they're less likely to come back to court continuously. And I think that that is judicial economy.
Our next question we will direct to Ms. McCarver. As a judge, would you consult precedents, former court decisions, or similar matters, as well as the United States and Missouri Constitution? And what are the steps that you would take to follow all three, before making a ruling? And then what supersedes which when making those decisions?
I would always consult precedent as a judge. I would make sure that any decisions that I would make align with the United States and Missouri Constitutions and any other appropriate law. The Court of Appeals and the Missouri Supreme Court issues findings on a regular basis that many judges will read on at least a monthly basis. I would plan on being the type of judge to make sure that I'm up to date on the law as it is changing, and it changes very, very often. I have had, as I stated, many cases in the Court of Appeals. I've had cases in the Missouri Supreme Court, and I understand how important it is to follow the appropriate law when making decisions, because otherwise cases go to the Court of Appeals in the Missouri Supreme Court. Most of all, I believe that a judge should follow the Constitution, and I had one case in front of the Missouri Supreme Court where, and there's an en banc, meaning all the judges sit on a Missouri Supreme Court case, and as the other attorney was arguing, Justice Wolf stood up and walked across the room. Now, I was not arguing at the time, but my heart was in my stomach, because why is this judge looking like he's walking out of the room? But what he did is he walked across the room and grabbed the Missouri Constitution. And he came back and he read the Missouri Constitution to us and stated, first and foremost, we should be considering the Constitution, what it says. That is what we should be applying to this case. And as a judge, I would seek to be that type of judge who follows the Constitution and considers the law before all things.
Mr. King, what is your response, sir?
Well, truly, as a trial judge, you have to rely on precedent. You have to find cases which fit the case that you have in front of you and apply that law to the case that you have in front of you. The United States Constitution is above all. If there's a United States constitutional provision which is an issue, you need to consider that first. Next is the Missouri Constitution. And then, of course, there is other court cases that are similar to the one that you have in front of you. I want to hear from the lawyers about what they think the appropriate law is, but I also do a lot of research myself to try to determine what the appropriate law is to apply in every situation. I think you have to do that. You start, of course, with the United States Constitution, but there usually, if you look hard enough, there is precedent. There is another court case, a Missouri case, that has been decided by our Court of Appeals or our Supreme Court that governs the case that you have in front of you. And when you have that kind of a case, it is, you have to follow that precedent. You really should follow that precedent. So that the parties can have some confidence in the ruling that you make. So that's the process I go through in every case.
Ms. McCarver, you have 45 seconds.
I think we have seen recently from the recent United States Supreme Court decision how extremely
you have to follow the legal precedent. That's why you're there. That's what everyone expects. If you do anything other than that, then you're not doing the job that you've been elected and sworn to do.
Our next question will be directed to Mr. King. As a lawyer, how many cases have you handled in probate court? In guardianship law, what burden of proof are you looking at before someone is declared to be incapacitated? And what's the difference between incompetent and incapacitated?
Well, as I said when I ran for this office 4 years ago, I had handled a number of cases that were probate cases. As a lawyer, cases involving guardianships, cases involving probate estates of folks that had wills, and folks that didn't have wills. I handled a number of cases after Judge Kelly, after I came here, when Judge Kelly would have mental health hearings, and I represented the state in those mental health hearings, so I had a number of cases of probate experience before I became a judge. Since I've been a judge, I've handled all the probate cases, all of them with the very few that are where I'm disqualified and another judge is asked to handle the cases. So I've seen all the cases since I've been the judge. In guardianship, the guardianship is set by statute, and I wrote it down so I could make sure that we all can come from the same definition, which is someone who's unable to receive or evaluate information or communicate decisions to such an extent that they lack the capacity to meet their own essential requirements for food, clothing, shelter, safety, or other care, such as serious physical injury, illness, or disease is likely to occur if they are not put in the care of a guardian. Those decisions are made by me quite often. Usually they are the result of folks coming to court and having some medical evidence that shows that this person has to be placed in care of a guardian. That is one of the most serious decisions you can make. When you take the life decisions, your life decisions, and you give them to someone else, there's not much more serious thing you can have as a judge. And so I take that responsibility very, very seriously. And that is a very critical thing of what we do. I'll talk about incompetent and incapacitated on the other side of this, but that is a very critical thing. That's clear and convincing evidence that you have to put someone into a guardianship.
And Ms. McCarver, it's time for you to respond, please.
I've been practicing for almost 20 years now. During that time, I have handled many different types of cases, which include probate cases. I have filed guardianship and conservatorships for both minors and adults. I have defended alleged incapacitated persons in probate court. I have drafted complicated annual and final settlements. I have had contested cases where a will has been contested, where deeds have been contested, where undue influence has been alleged, and where trust amendments have been contested. I even have taken one probate case to the Court of Appeals, which occurred last year. I have drafted multiple estate planning documents for many private clients, including wills, powers of attorneys, deeds. I first began handling probate matters when I worked for a solo practitioner in Lawrence, Kansas in 2002. I handled a number of probate matters when I worked at Kramer & Ham from 2004 until 2010. And I have handled probate matters in my private office in Farmington since 2010. I have worked on probate matters in both the states of Missouri and Kansas, in many different counties. And I would say I've handled perhaps between all of those different places, although it's a little difficult to count, perhaps 100 different probate matters in my time in private practice. The burden of proof for adult conservatorships and guardianships is clear, cogent, and convincing evidence. I'm not sure many of you know what that is, but it's said that it must instantly tilt the scales in one direction. That is what clear, cogent, and convincing evidence. That was a bit confusing previously between minor and adult guardianships and conservatorships, but the Missouri Supreme Court has defined that for us a little bit better since 2017.
Mr. King, you have 45 seconds to respond.
Well, the third part of the question talks about what's the difference between incompetent and incapacitated. The definition I just read to you is the definition of incapacitated. You have to find someone that suffers that way they go into a guardianship and they are determined to be incapacitated. Before the probate code was changed almost 40 years ago, everyone was considered incompetent if they had some certain definitions. That's been changed. When the probate code was changed, they also gave opportunities for folks to live in the least restrictive environment, and they're looking for those opportunities. So it's a narrowing. Incapacitated is narrower than incompetent. I did it.
Ms. McCarver?
There is a state statute, RSO 1.021, that gives us a definition of what is incompetent. Sometimes probate courts don't look at this. Incapacitated means if a person is unable to meet their needs for food, shelter, clothing, and health care due to some type of medical problem that they have, or possibly a mental health problem. Disabled means if a person is unable to meet their financial needs and are unable to take care of their property and other issues such as that. I have actually had one situation where a person was in a coma and his wife had to seek one of these from the court, and of course he was not able to meet his reasonable needs.
We'll go on to our next question. This one will be directed toward Ms. McCarver first. How do you handle a descendant estate where you essentially have a pro se individual struggling through the process without the assistance of an attorney?
Well, clearly I'm a private attorney now, so I've not had this situation come up as a judge. If I were acting as a private attorney, of course, I would fight zealously for my client, even if the other party is pro se. But when you're a judge, you step into different shoes. And you're not allowed to take a role of the advocate any longer. And therefore, we cannot help a pro se person as a judge with their paperwork in any type of case, including probate cases. Additionally, the court clerks are also not allowed to help parties who cannot fill out their paperwork. In court, sometimes you can suggest if a case is clearly too difficult, that person may want to seek the advice of an attorney. But we are not able to step into those shoes of an advocate and do that case for them because we are told that that is inappropriate to do if you are a judge. There are some courts who have different forms and explanations for parties, and including the 16th Circuit, which is over in Kansas City, which might help people more. But as a judge, you just clearly are unable to step into the shoes of an advocate, and you are not able to help people fill out the paperwork if they are not able to do it themselves.
Mr. King, how would you respond?
Well, in my experience, a lot of folks who come to probate court are able to be helped in various ways. First of all, many of them can go under the law that provides if you have an estate under $40,000, you can fill out an affidavit and file it with the court. The clerks will not fill that affidavit out, but they will provide folks with the affidavits, which are fairly self-explanatory. There are also various forms that you can fill out when you're a surviving spouse or a child, dependent child, and you want to forego the process of trying to get what they call letters, which is a fancy term for a probate order of power, and you can go ahead and, as a spouse, you can refuse and go past all that, and those forms are also available to folks. So those are some forms that folks can fill out on their own. They don't have to have lawyers, and the clerks will not help them, will not practice law, will not show them exactly what they should say, but they will help them with the forms. Neither I nor the clerks can serve as a lawyer for people. We can't serve as a lawyer for them. We can't tell them what they may have done wrong. We can't help them get through the proper, if they've got a large probate estate. And so in most of those large probate estates, they will need to talk to the lawyer before they go too much further because the stakes are too high.
Ms. McCarver, you have 45 seconds to respond.
As a judge, judges are told that it's unethical to assist a party, it's unethical to step into those shoes as an advocate. As a private attorney, I'm able to do that, but if I were a judge, I would no longer be able to do that. And as a judge, you have to follow the law. You have to follow the ethical rules of being a judge. Many people can be helped by online forms, or forms that they receive from the clerks, but we, in probate cases, and actually in all types of cases, judges are simply not able to help the party understand situations if they are struggling through a difficult process, and those people, or the judge can't say, you should see an attorney.
Mr. King?
I said what I said earlier, is pretty much where we stand as far as helping folks. There are a lot of forms that we have that will help folks in situations where the estate's below a certain value, where the facts fit. But if you have a larger estate, you will need to talk to a lawyer.
The next question we have is a big one. Everybody has heard about the decision Roe v. Wade. The question we're going to pose to the candidates is simple. Roe v. Wade was recently overturned. Since you are both legal scholars, we can assume you've read the original opinion. How would you say the amendments cited in Roe v. Wade opinion were applied? Do you believe the Supreme Court was wrong then or wrong now? And give us an explanation of the amendments for those of us who really don't know them. Mr. King, I'll throw this question to you first.
Thank you for throwing that question to me, and I'm going to disappoint you a little and say the following. I don't think it's appropriate for me to answer the question the way that it's asked. I am, like you, very, very vitally interested in this issue. We'll talk more about that in just a second. I think everyone's pretty much familiar with how Roe versus Wade has affected everyone's lives, and everyone is familiar with the fact that a few weeks back, the United States Supreme Court essentially overruled Roe versus Wade. The majority, led by Justice Alito, said that there's no federally protected right to an abortion, and that states could make abortion restrictions. One of those states is Missouri. That having been said, however, it is not for me to criticize the United States Supreme Court or to congratulate the United States Supreme Court. It's my responsibility as a judge to follow the law as it is written. Regardless of my personal feelings, I have to follow that law as the Supreme Court has handed it down, whether I agree with it or not. I think my credentials as a member of the pro-life movement are pretty solid. I think most people, and I see some of you out in this room that know that I've been very involved in organizations such as the Parkland Pregnancy Resource Center. That's all fine and good, but you have to set all that aside when you walk in the courtroom. You have to make your decisions based on law and evidence, not based on your personal feelings. And so my feelings about how Roe versus Wade has affected our lives, or my feelings on the Dobbs case, notwithstanding, I have to follow the law as the Supreme Court has handed it down. And that's where I stand.
Ms. McCarver, your response, please.
As we know, Roe v. Wade has been overturned pursuant to Dobbs versus Jackson Women's Health Organization. That just occurred less than a month ago. Previously, Roe v. Wade relied on the 4th, 5th, 9th, and 14th Amendments, as a lot of amendments, to state that there's family privacy that allows this right to an abortion. I think that the Supreme Court most recently has stated that if we look at those amendments, and we look at the Constitution as a whole, a right to abortion is not listed anywhere in any of the Constitution. And the U.S. Supreme Court has stated that although there's prior precedent, or as it's called stare decisis, if you want to be fancy about it, they should be able to look back and correct what they believe was a mistake that was made back in 1973. That courts should not substitute their social and political opinions for legislative opinions. That is what the U.S. Supreme Court has stated. And also the U.S. Supreme Court has stated that in their opinion, Roe v. Wade stopped the normal political development of this issue within the states. As most of you probably know, following this decision, the right to decide how to make laws regarding abortion has been returned to the states. And the U.S. Supreme Court has stated that it's their opinion that that is how we should handle the situation. And as a person, if I'm honored enough to be a judge, I will follow the law. And whatever the law is, I will not insert my own political or personal opinions. I am a pro-life person, but I will follow the law as a judge, however it's written.
Mr. King, you have 45 seconds to respond.
I said what I said earlier. I think I stand on what I said earlier as far as my feeling about how I as a judge should proceed, even though I may or may not agree with what the Supreme Court has done or said.
Ms. McCarver?
Nothing further.
Sounds like we're in court, doesn't it? Nothing further.
Nothing further.
Our next question we're going to pose to Ms. McCarver first. As a judge, many times both parties in the case will be dissatisfied with your decisions. What is or would be your approach to explaining rulings? If you thought about it later and realized you'd made a mistake, would there be any action that you could take to resolve it?
And with regards to the issue of explaining rulings, what a judge, in my opinion, should do is write a detailed enough judgment that it explains the court's decision so that it is explained to the parties properly and they understand what law and facts the court was applying to the situation. We are, as judges, are not able to have ex parte communications with people. So after you issue a judgment, you can't sit down and explain to them why you made that decision, and therefore you must put all of that information within your judgment so they can see why you made that decision. A private attorney could file a motion to amend or a post-trial motion and ask a judge to review the decision that they have made. And I, throughout my practice, have respected judges always who can look back at a case or a judgment and understand that sometimes they make a factual mistake or a legal mistake and can correct that mistake that they've made. I had a case not too long ago over in Washington County where I filed a motion in front of the judge and stating that I did not believe the other attorney should be able to assert affirmative relief because of some pleadings were not filed that needed to be filed. The judge denied that motion, but overnight looked at the law and came back and said, Julie, you know what? I was wrong. You were correct about the law. And I looked at it again and I changed my mind. And that is the type of judge I have always appreciated. A judge who is humble enough to look if it's brought to their attention in an appropriate way and say a mistake has been made, if it's been made, and correct that mistake. And I would hope if I had the honor of being a judge that I would do that as well.
And Mr. King, your response, sir.
I think you speak through your written judgment. I think it is wrong for you to talk about the way you're going to rule instead of putting it in the written judgment, because sometimes those two can vary. You don't want that at all. You want it to be in the written judgment. And these cases are very, very important cases. As I said earlier, I take every case that is contested under advisement. What that means is I take it back and I think about it and I try to make a decision based on the facts, the law, and the evidence. And so you're not making that same judgment. You're making a decision after you've had a chance to think about it. So you want to express yourself through that written judgment. And that's available to everyone. The minute you file it, once they know it's on file, they can all look at it, read it. If they've got lawyers can help them get through it. Now, I am not so naive as to think I get everything right every time. If I've made a mistake, I absolutely want someone to point it out to me. And I want them to point it out to me while I am legally able to do something about it. Legally able to go back and say, oh, I made this decision, I should have made that decision. And usually, when you have a case where it's been hotly contested, the lawyers will come back to you and both want you. Sometimes they both want you to change the ruling that you made, and you have to listen to their arguments and determine whether or not you did make a mistake back when you ruled a certain way. But I agree. I don't think you should wait for the Court of Appeals to tell you, which has not happened yet, but you wait for the Court of Appeals to tell you that you made a mistake, rather than having the lawyers in the case tell you, hey, this is something you need to look at. But that's the process, not explaining it to folks, rather letting the written judgment do the talking.
Ms. McCarver, you have 45 seconds to respond.
A different section of that question was whether or not there would be cases where a party might be dissatisfied with a court's decision. Sometimes, especially in domestic cases, everybody's dissatisfied after a judgment. And a judge cannot allow the worry that somebody might be dissatisfied to sway their decision. A judge should always apply the law correctly and do what's right, and cannot be swayed by the possibility of somebody being dissatisfied.
And Mr. King.
Right, you can't worry about, you have to assume people who want a certain thing are going to be disappointed when they aren't awarded that. The best you can do is give them every opportunity to tell you why they think they should have it, so that they at least feel as if they were listened to by the judge. But there's always going to be dissatisfaction with the rulings that you make.
Let's get away from some of the more serious questions, and let's delve into something here a little bit different here. We're going to ask each one of the candidates up here, and we'll start with Mr. King first, about what U.S. president you have admired the most and why.
Well, if you've been around me for any length of time, or you've been in my office, you'll see that I have a picture of Abraham Lincoln. Abraham Lincoln, and I'm borrowing, I guess, for lack of a better term, some of what Fred talked about a few minutes ago. Abraham Lincoln knew, in the time in which he worked, that all you had was your reputation for honesty. That's all you had. People couldn't look you up on the internet. People couldn't read about you. They had to hear about you from someone who knew you to determine whether or not you were honest. And so Abraham Lincoln, from the very beginnings of his public life, he determined that he was going to have a reputation, above all, for honesty. He told young lawyers, please be an honest lawyer, but if you can't be an honest lawyer, don't be a lawyer, but make sure you're honest. And so it's very, very important for us, as we reflect on the life of Abraham Lincoln, that he led our nation through some of the most difficult moments in its history, but he never gave up that essential quality of honesty. And honesty is the quality from which everything else flows. And so I have no hesitation in saying that I admire him, because he lived a life in which he said, I am unafraid of what people say about me because I know who I am. And at the end of the day, he was honest above all. And that is why that's not the only reason why I admire him, but that is one of the most important reasons why I admire him. It's worth remembering, Fred, that not only did he not have any formal schooling, he didn't have a whole lot of family life, as you and I would call it. He had to learn a lot of his culture. A lot of his culture came from just the life he lived. And it's amazing the life he lived based on the beginning that he had.
Ms. McCarver, I'll ask you the same question. Which U.S. president have you admired the most and why?
That would be Ronald Reagan. As we all know, our country has some serious problems right now. Our economy is not very good. We have high gas prices. I know that many young mothers are having difficulty buying formula for their children. And under Reagan's the economy was amazing. And he was well respected. He was very well spoken. He was the type of person who demanded respect. Prior to his being the president, as we know, those of us who are old enough to know, there was the Iranian hostage crisis, and there were hostages who were held under the former president for 444 days. Following that, Ronald Reagan was elected, and he was coming up on being sworn in, and we didn't have all the 24-hour news stations like we did now. We had maybe one. And the news station was commenting, oh no, Ronald Reagan is about to get sworn in. They better release those hostages immediately. And as he was being sworn in, the hostages were released. And that is the type of man who demands respect and receives that respect. And that's why he's one of my favorite presidents.
Mr. King, any further words?
No, I think that's, I think if Abraham Lincoln were here, he'd probably tell us who set it up.
Ms. McCarver, I'll throw it back to you for final comments.
I'm not going to try to divine what Abraham Lincoln would have said.
All right, very good. Carrie, did you want to say anything? That's the conclusion of our questions.
Well, we're gonna have a short 10-minute break, and then we'll come back for round 2. Everybody can go use the facilities and grab a bite. And thank you so much, Judge King.
We'd like to thank our two panelists.